Hello everyone and welcome to Internet Law Review. For today's video we are starting a case study. This is the case of Stephen Elliott versus Maria Donegan. And what we're going to do is we're going to look at every document that is filed in this case and comment on them as far as we go. So this is a brand new case that has just been filed, and so all that we have right now is the initial complaint, and we're going to take a look at this. Now the subject matter of this complaint is that Stephen Elliott was named in a document that Maria Donegan and other people that are unknown, that's why they're labeled as Jane Does, compiled together, which detailed alleged sexual assaults by people in the media industry. So the concept here is that Maria Donegan and these other people forwarded some emails and other electronic correspondence that named Stephen Elliott and others as supposed sexual offenders in the media industry. And Stephen Elliott is suing for defamation, which is a false claim against his reputation, among some other things. So we're going to take a look at this initial complaint and make some comments as we go as to what we think about this cause of action. So this is Stephen Elliott versus Maria Donegan, and we're going to get started here. All right, this action is brought by plaintiff to recover, among other things, damages caused by defendant's libelous communications of knowingly false statements in a publicly accessible, shared Google spreadsheet circulated via electronic mail to parties' professional colleagues, namely women in the media industry. Upon information and belief, defendants conspired to create a Google spreadsheet entitled Shitty Media Men, herein referred to the list, and circulated the link to the list via email without password protection for the stated purpose of encouraging the female recipients to anonymously publish allegations of sexual misconduct by men. The wholly unsubstantiated allegations published in the list, particularly with regard to allegations about plaintiff, contained numerous false statements alleging criminal sexual conduct on the part of plaintiff. Participants interested in contributing to the list, including defendants, published defamatory allegations without corroborating evidence or means of assessing the credibility of the claimants. The list contained false information and unsubstantiated allegations, including untrue statements alleging the plaintiff engaged in criminal sexual conduct, namely rape accusations, sexual harassment, coercion, and unsolicited invitations to his apartment. The inflammatory false statements published in the list were abusive, vulgar, intentionally misleading, as well as damning to the plaintiff's reputation and good name. The list was sent to numerous members of the party's shared profession, the media industry, to intentionally harm plaintiff's reputation and further cause harm to plaintiff's career. Plaintiff is a private citizen who is neither a politician nor celebrity. I highlighted this in red because I want to make sure to comment on specifically. The reason that statement is particularly important is because defamation has two different standards depending on whether the person is a public person or a private person. If it's a private person, what you need to show is that the statement is false and is injurious to a reputation. If it's a public person, you also need to show that it's made with malice, which is to say that it's made with a knowing falsehood or with reckless disregard to the truth. So the standard for a private citizen is much lower than it is for a public person. So a good example of a public person would be something like the president. You know, if you're going to say something that's false about the president, not only does it have to be false, but you have to show it's knowingly false and it is or recklessly disregarding of the truth. And obviously that's very hard for someone like the president because he's not only a public citizen, he's probably the most public citizen. But for average normal Joes off the street who are private citizens, you don't have to show the actual malice. You just merely have to show the falseness, and you have to show some sort of harm to reputation. So that's why I highlighted that sentence. The court has diversity jurisdiction and supplemental jurisdiction in excess of $75,000. That's why we're in federal court. That's the basis for federal court action. And the diversity is here that the plaintiff is a resident of New Orleans, Louisiana, and the defendant is a resident of Kings County, New York. We're suing her in the Eastern District of New York, which is a good place to sue her because that is the place of her residence, and so the court will have jurisdiction over her because she lives there. Plaintiff will know through initial discovery the names, email addresses, pseudonyms, and/or internet handles used by the Jane Doe defendants to create the list, enter information into the list, circulate the list, and otherwise publish information in the list or publicize the list. Through discovery, plaintiff can obtain the email address information, Google account, internet protocol addresses assigned to accounts used by Jane Doe defendants by the account holders of the ISPs, email accounts, and/or Google accounts on the date and times at which the posts were published and/or information was entered in the list. Plaintiff intends to subpoena the shared Google spreadsheet metadata for the list, email accounts, Google accounts, and ISPs in order to learn the identity of the account holders for the email address and IP addresses. So the fact that this is a shared Google document account is going to be very helpful to the plaintiff here, and that's why he's highlighting all that stuff. Every time you make a change in a shared Google document, it makes a record of the change in the metadata to show who, what, when, where, what, that kind of information. And that information isn't necessarily shown to the user, but it is retained by Google. So it allows you to determine exactly who, what, when, where, exactly who contributed to what, and allows you to isolate who made the statements in particular. So that will be very helpful. So he's saying here, look, I have a reasonable belief to believe that I can get this information through discovery, and I believe that that's probably true. Though an email address or IP address alone does not reveal the name or contact information of the account holder, it does reveal that the person's full name, other identification, and or physical location. The reason that's important is because there's case law on point that basically says that merely an IP address is not sufficient to identify a user and cannot be identified a user. Now, if memory serves correctly, that case law is from the Ninth Circuit, and this is not in the Ninth Circuit because this is in the state of New York. But nevertheless, it is persuasive legal authority, and so he's sort of making this statement as a preemptive note of that to say, look, I'm not just relying on the IP address. I have other ways of getting this information, and he's right to do so. Plaintiff believes that the information obtained in discovery will reveal the Jane Doe defendant's true names, addresses, and other identifying information, allow plaintiff to amend this complaint to state the same. Plaintiff further believes the information obtained in discovery may lead to the identification of additional parties to be added to his action as defendants. Fair enough. I'm not particularly sure why he said Jane Doe 1 through 30 as opposed to some other number. I'm not sure on what basis he thinks that there are 30 of them. I would have said something like Jane Doe's 1 through 100 or Jane Doe's 1 through 10. It just doesn't, I'm not sure why he picked 30, but he can absolutely amend it as he gets further information if he gets to discovery. And to get to discovery, all he has to do is make it pass a motion to dismiss in summary judgment. Upon information and belief, each of the defendants named herein, including defendants Donegan and Jane Doe defendants, performed, participated in, conspired to commit, or abetted the acts alleged herein and proximately caused the damages alleged, and thus are liable to plan for damages and relief sought. Proximate cause is a legal standard in torts. You not only have to show it's the actual cause, but you have to show a proximate cause, which basically means that it's close enough to the injury to count. How close you have to be is a little bit nebulous, but the idea is that you can only go so far down the chain of causation, that something caused something, caused something, caused something. There's a limit somewhere, and he's just saying that this is close enough to count. Plaintiff is an author living in New Orleans. He has published multiple books and articles expressing his sexual preferences in these nonfiction works, of which defendant is aware. Plaintiff openly describes his sexual preferences in detail so that it's clear that he could not physically participate in false, unsubstantiated allegations published about him in the list by defendants. Okay, that statement I do not buy. Just because you have particular sexual preferences of one kind or another does not mean that you're not able to physically participate in the actions. You may not have a desire to participate. You may not want to participate. But to say you can't physically participate would be to say that you are literally physically incapable of it. You could not do it. And unless there's a deformity, which he's not mentioning, his sexual preference alone would not preclude him from physical participation. So that sentence I do not buy. On or about October the 11th, defendant conspired to create the list of publicly accessible shared Google spreadsheet entitled Shitty Media Men for the stated purpose of encouraging women to anonymously publish allegations of sexual misconduct of men. It was accessible via a link which was circulated without discernment, but for the caveat it should not be forwarded to men. So it was just shared wildly without any attempt to share it among trusted people, which goes to a standard of recklessness, is basically what that's trying to prove. The allegations were wholly unsubstantiated. Indeed, participants interested in contributing to the list, some of whom were Jane Doe defendants, were encouraged to publish any and all defamatory allegations without evidence to corroborate the allegations or means of assessing the credibility of the anonymous sources. I'd want to see some proof that they were actually encouraged to do that, some sort of statement to that effect. On or about October the 11th, defendant published plaintiff's full name in the list along with several names of several other men connected to the media industry. Plaintiff's name was entered number 13 along with affiliation of freelance writer novelist. Defendants further published the defamatory allegations of rape accusations, sexual harassment. Sick just means literally what the words are. So if there's a misspelling and you want to make it clear that this misspelling is intended because that's the way it was, you just write SIC, which just means this is literally what they wrote. Under the alleged misconduct column heading, plaintiff's entry was amended by defendants to read rape accusations, sexual harassment, coercion, unsolicited invitations to his apartment, I'm not sure what exactly a solicited invitation to the department would be. Exactly what would that be? Even in theory, it's like, invite me, but that would in and of itself be an unsolicited invitation. I mean, someone has to make the first unsolicited invitation, right? How would you? Someone has to do it. I'm not sure what that's supposed to mean, but whatever. A dude who snuck into binders, and defendant published multiple women alleged misconduct in the notes of the list. Defendant Donegan, both herself and together with some of the Jane Does, actively edited, removed, organized, contributed, highlighted, published, and added names to the list, going to their participation. At the top of the list, defendant Donegan wrote, men accused of physical sexual violence by multiple women are highlighted in red. Defendant Donegan, both by herself and with some of Jane Doe defendants, outlined plans to entry on the list in red among some of the other individuals named on the list. I don't think I would write defendant Donegan here explicitly unless he knows that somehow for a fact, which I wouldn't commit to that because you can just deny it if it was someone else. And I'd just say one of the defendants rather than defendant Donegan. Defendant Donegan, along with some of Jane Doe defendants, outlined defendant's entry in red with malice to signify his being accused of physical sexual violence by multiple women. Statement defendant Donegan, at least some of Jane Doe defendants knew or had reason to know was false. Again, if it's his sexual preferences, that's not reason to know it's false. On October 12, 2011, BuzzFeed published an article about the existence of the list. Articles referencing the list in the New York Times, New Yorker, Atlantic, Harper soon followed. This is going to go to damages, showing it's widely disseminated. On or about and between October the 11th and July 17th, and many times following the creation, they publicized the existence of the list. On or about October 11th and July 17th, defendant Donegan made public statements on social media saying, the problem is men, I really hate men, I really like the witch hunt, and republishing statements assuming guilt of all men accused on the list, which again goes to a bias issue and goes again to a conscious or willing disregard, a conscious desire to avoid the truth because of bias. In or about December 17th, plaintiff was told by a producer that the producer could not forward his work to film or production customers. This is going to damages. Following continued publication, multiple publication for the list, plaintiff was unfriended or blocked by many friends. Damages. Defendant Donegan published an article in New Yorker entitled "The Cut," taking credit for creating and disseminating the list article entitled "I starred the Media Men List. My name is Maria Donegan." Well, that's pretty good evidence to implicate Maria Donegan in the creation of the list and some sort of editorial control over the list, because the person who creates a Google document, Google spreadsheet, has a lot of authoritative control, editorial control over that. So that definitely gives us a clear statement on the record of why we're suing this woman in particular. So that's fine. But again, unless we get another statement explicitly, we can't attribute any specific action to her. So I'd still criticize above where he said defendant Donegan did something in particular, because he doesn't know that. In or about January 18th, plaintiff enrolled in therapy while actively contemplating suicide, going to damages. Defendant Donegan has benefited substantially from publication. In addition to favorable publicity, defendant Donegan has been hired on contract at New Yorker, was given a contractor. You'd have to show a causal link between the two things. Just because one thing happened after the other doesn't mean it happened because of the other. And it's also not particularly clear why that would matter, because the damages are to him in terms of defamation. Her ability to profit off of it isn't really an element of the tort, but I guess it shows some sort of, it probably goes to the intentionality of it. If you can show some sort of design that this was a stated purpose of it in some respect, then perhaps, but you'd have to develop that out more fully to go to the intentionality of it. Otherwise, I don't know really why it's here, because it wouldn't go to damages. Defendant's actions were malicious in nature and taken solely to damage plaintiff's reputation and career. I mean, solely? Presumably there were other reasons, and not for the least reason that other people were named other than the plaintiff. So I would soften that language a little bit. Defendant published a list with reckless disregard for the truth of the allegations asserted and circulated a list to numerous women in the media industry with the intention to list be forwarded in perpetuity. Given the statements that we have, we can say that to be true. Defendant knew the list contained false statements, including the entry of plaintiff entry, but published a list of numerous women to intentionally injure, harass, defame. Again, he hasn't established that they knew about them being false. That isn't a standard, by the way, that you have to prove in the case of a private citizen. That would only be a case of a public actor, but he hasn't established that yet. As a direct and proximate cause of the defendant, plaintiff has required therapy. Okay, great. So the causes of action: defamation of character and libel. So defamation, basically, you have to show that it's a false statement, it's made in a way that is injuring, and you have to show some damages about it, and it goes to some aspect of the character of a person. So truth is an absolute defense, and you would have to show its falseness. Okay, defendants are aware that published statements are false because plaintiffs publish sexual preference, including his preferences as submissive male and BDSM. That doesn't show falseness. Whatever his preferences are, I don't care how strong his preferences are. It doesn't really go to the issue of, do they know it to be false? I mean, his ability to physically perform the acts does not appear to be challenged. So even if his preferences are well known in the industry, I don't think it quite goes to the idea of it knowingly false. You'd have to show more. Plaintiffs publish this defamatory information without privilege or authorization. Defendant published the false statements about plaintiff with malice as they knew the statements were false. No, I don't think so. Defendants also published and circulated lists with reckless disregard for the truth. Yes, now we're on to something real. Reckless disregard, yeah, that we've got in spades, no problem. Assuming everything here is true, of course. This is a pleading, so it's written in the most favorable light to one side. So assuming everything is true, yeah, we got reckless disregard for days. Defendants' false publication achieved their desired effect of exposing plaintiff to contempt, aversion, and vitriol. Can you really say that's a desired effect? I mean, that goes to intentionality of the purpose of it, which is not really the point. To show intentionality, you just have to show the intentionality of the statement. You don't have to show a particular design in making it. You don't have to show a reason for it. And it's not really clear on the record so far that was in fact their desired effect. The desired effect could be warning. The desired effect could be a lot of things. Plaintiff is entitled to per se damages because defamatory statements made by defendant were inherently harmful as they address sexual morality and professionalism. So in defamation, there's a thing called defamation per se, and it relates to certain statements, among which are sexual reputation. So this would be an example of per se. Basically, in a per se case, you don't have to show any damage. So that's what it means to be per se. In per se, all you have to do is show falseness and show that it relates to an element of character. You don't actually have to show damages. The per se means the damages are presumed. They're just assumed by law to exist. Plaintiff is further entitled to actual damages, compensatory damages, and punitive damages for the malicious defamatory conduct as plaintiff has been damaged in the amount to be determined. Okay, great. All right, second cause of action, intentional infliction of emotional distress. Intentional infliction of emotional distress is really hard to prove. You have to show that you are deliberately intending a particular person to have a negative emotional reaction. So it is a difficult tort to prove. But let's see what they got. In publishing the list with intent to inflict said emotional harm, defendants were condoning publication of inflammatory and substantial allegations and permitting the publication of false information with actual knowledge of falsity. No. Deliberate indifference to and apparent approval of publication of false allegations, maybe, with the consequence that the plaintiff has been effectively blackballed with a ruined reputation and denied well-earned economic opportunities. As a direct and proximate result of the above conduct, plaintiffs sustained tremendous damage, including without limitation, emotional distress, loss of career opportunities, and other economic injuries and other direct or consequential damages. See, no, that is not enough to show intentional infliction of emotional distress. He's showing damage, but that's not the issue. To show intentional infliction of emotional distress, again, you have to show a specific, targeted, intentional design. And he's saying, well, I've been harmed, but that is not quite what it is. So I don't think his intentional infliction of emotional distress claim is particularly well pleaded. I don't think it's well developed. Negligent infliction of emotional distress, much more promising. Negligent infliction of emotional distress is much, much easier to prove. Defendant negligently defamed plaintiff and negligently inflicted emotional harm by creating a list and publishing the unsubstantiated allegations about plaintiff. Yep, that would do it. Defendant were condoning the publication of inflammatory, unsubstantiated allegations and permitting the publication of false information about plaintiff with actual knowledge of falsity and deliberate indifference to and apparent approval of publication of false statements. Yeah, the false allegation here would be that he's a rapist, and just in general. So that should be fine. Defendant knew or should have known the outrageous conduct would result in consequence the plaintiff has been effectively blackballed. Yeah, I will do it. Although knew or should have known is not actually this required standard, because that would technically be intentionality, and you would not have to show that in a negligence case. You could just say that with disregard to the duty is basically negligence. Negligence is really low. Negligence is basically what happens if you're in a standard car accident. That's negligence. It's like, it's not that I meant to do it. It wasn't even necessarily I was just not careful. It's just like I had a duty and I didn't follow through. That's negligence. And here they had a duty not to publish false stuff, and they published false stuff. I mean, that's all you have to show negligence. So know or should have known is not necessary, but okay. As a direct and proximate result, plaintiff sustained tremendous damage, including without limitation, emotional distress, loss of career opportunities, other economic injuries, and consequential damages. Sure. Again, you're going to go to the direct and proximate result. So a direct result would be exactly one step on the chain of causation, and proximate result would be close enough. And I think given the pleadings here, this would definitely fall within the close enough boundaries for proximate cause. Prayer for relief, just a fancy word of what are we asking for? The court's finding that the information was false, so we're asking for declaratory relief. The court to just declare something to be true. The court finding that the defendant published the false statements with malice. Okay. Damages in the amount to be determined at trial and no less than $1.5 million plus interest, attorney's fees for the first cause of action. Okay, that's a reasonable number for given what he said. This award of per se damages the amount to be determined at trial, but no less than $500,000. Okay. The award and actual compensatory damages the amount to be determined, but no less than $500,000. That's again pretty reasonable for compensatory damages. The award for punitive damages amount to be determined $500,000. Yeah. Attorney's fees against defendants jointly and severably in amount to be determined at trial. So that I highlighted this in red to bring special attention to it. And what that means is when you're suing someone jointly and severably, what that means is that everyone is liable for everyone else's actions collectively and individually. So let's say that for whoever's left in this thing. So let's say there are 30 Jane Does and we lose 15 of them along the way for various reasons. So we've got, let's say we have 15 people left in this thing at the end of the day, and we have damages of $2 million. So what that means is that we can get that $2 million in any combination we want from any of the defendants. We can't get it more than once, but we can get it from anyone or individually or collectively. So it's up to us what we want to do as the plaintiffs at that point. We can spread it out evenly. We can just tax one person with all the damages, in which case they would have to then sue their partners for compensation for their contribution. But the plaintiff doesn't have to make that problem. So it's like if one person has a lot of money, then just get the money from them. It's easy. And this is typically done in insurance cases. You typically name the insurer as part of the complaint, and then say it's joint and several liability, because the person who actually caused you the damage may not have any money. Insurance company does. But hypothetically, once you have a joint and several liability, you could get all the money in any fraction from any of them. But of course, you always get it from the insurance company because they have the biggest pockets and it's easiest. But it's up to you. That's what joint and several liability means. Everyone is collectively liable for everyone in any amount that is determined. On a second cause of action for intentional infliction and judgment of award to be determined, including without limitation, damages to psychological well-being and career loss, as well as future career prospects. Okay. Third cause of action, amount to be determined, same thing. And then such further relief as the court deems just and proper, which can be written many, many, many different ways, but it is always the last sentence of every lawsuit ever, is, by the way, anything else that I forgot to think of. You always put it at the end, so it's always kind of nice to see it in a lawsuit because it means the attorney was thinking. It's rare not to see it because it's so common, but it's nice. So anyways, that's the story of Elliott Rogers, or not Elliott Rogers, sorry, Stephen Elliott. Stephen Elliott and Maria Donegan, this lawsuit that's just been filed. I'd like some feedback on this in terms of the presentation. Obviously, this is long. It's 25 minutes that I've been talking about this. I tried to make it as brief as I could, talk about things and highlight issues. Obviously, there's other cases I'd like to do briefing on, but I'd like to know how you're liking this in terms of the flow of presentation, my explanations. Are there things I should be cutting, things I should be talking more about, less about? Should I break this up into multiple parts? Should I have done this in like 3 different parts, 3 different videos, and like 10 minutes each? Should I do that? Or do you like this as one flow? Give me some feedback so I understand what you guys like, and I can try to accommodate your needs, and let me know what's going on. But I think it's really, really interesting. My initial impression is I don't think the ID claim works. I think the standard negligence and defamation and the negligence infliction of emotional distress argument works. And I'll be very, very interested to see what the defense is going to be. Because based on the facts as they're presented so far, and again, this is a one-sided presentation, but based on the facts so far, yeah, this is a pretty standard defamation case. It reads like a whole bunch of stuff false. There was a bunch of people who cooperated to publish false things. They published them. It got reputation. I was hurt by them. These are false. Yeah, should work. So it'll be really, really interesting to see how that's balanced, especially given the whole Me Too movement right now in terms of, because the argument from the defendants is going to be something like, that here's how I would write it, in other words, because I can't speak for their lawyers. I don't know what they would write. But here's how I would write it if I was their lawyers. Sexual harassment, sexual assaults has been a long simmering problem in Hollywood. The Harvey Weinstein thing is well known. Casting couches are well known. Give like 10 other examples of all the horrors of sexual assault that are generally known. And the women have an interest in protecting themselves, and this is this is just an attempt to make people aware of things that have been said so that they can give an extra note of caution. It wasn't intended as a statement of fact. It wasn't intended to be. It was just simply saying, hey, keep your eye out. It wasn't intended to be whatever. It just got out of control. This is something we really need in Hollywood. This is really important because we have all these issues. I would probably give statements from some of the Jane Does themselves in my response, basically ways they've been specifically harmed, not necessarily with respect to this guy, but if you can find it with respect to this guy, that'd be ideal, where people go on the record saying, yeah, he did these things to me, so I know they're not false. If they get that as response, that would be a really good response. Otherwise, I'd give some sort of generic response of people. Generally, these are well known. Generally, in these other examples, we knew them to be well known, so we took people's word for it. Believe women, believe survivors is going to be the kind of theme. So that's how I would develop that, and see where it gets me. It's tough on the law though. It's because it does fit a standard defamation case, because there was no attempt to vet anything. There was no attempt to corroborate anything. There was no attempt to validate anything. It's just anyone apparently could go on this thing with no protection. No one had to sign their name. Anyone could just say anything at any time about any person, and they opened it up completely. I mean, that seems pretty negligent on standard case law. But it'll be really interesting to see how this develops in terms of where it goes, or how people respond to this, or if the court wants to somehow move the law with respect to Me Too or respect to Hollywood sexual assault in general. It'd be interesting to see if they try to get this transferred into California. I don't know if they'd have any cause to. It seems like a proper venue. But it'd be interesting to see if they get this transferred to the Ninth Circuit, and see if they can pick up some of that case law that's a little bit more favorable to them, perhaps in New York. So I'm really, really looking forward to this response, seeing what they have in offer, seeing what they want, if the law they think is different than it seems to be. But so far, really strong complaint, looks right on the law, looks very, very plausible. It's a strong showing. It's a little thin in places, but it's an initial complaint. An initial complaint, you just have to show a notice. It's what we have notice pleading. So you're under no legal obligation to spell everything out in excruciating detail. You just have to put people on notice of what you're accusing them of in a very sort of general way. And this is more than enough for notice pleading. So I would expect a response of some kind. A motion to dismiss, I don't see. There is a cause of action valid unless there's some sort of prior case that I don't know about in this specific matter, so it's already been adjudicated, then it'll be a res judicata dismissal. But barring some sort of unusual thing that I'm not aware of, I don't see a motion to dismiss. I don't see a motion for summary judgment working right now from either side because there are facts that need to be more well developed. I could see theoretically the IIED count being dismissed in a summary judgment, but I don't think this entire case is going to go away. So I think this is going to go to a discovery. So we will see what they respond with, and we will see what they're saying in terms of law, and we'll analyze their legal claims and see if it's any good. Again, I'd like some feedback on if this is working for you, so that when I do the other case that everyone cares about, there'll be more to what everyone's expecting. Well, that's all for now, my friends. We will post more as we get more in this case. This is the only document that's been filed so far, but we will get more, and when we do, we'll cover it. So for now, my friends, that's all. Cheers. Bye.